I want to start out by thanking Dr. Isailovich for the kind invitation. And I have to say that this is my first post-pandemic in-person talk. So this is quite a novel but also familiar experience. I'm really excited to be here. The other novelty is that when the essay was published, COVID struck. And I was actually not able to present it in any setting or have a discussion around it. So I would be really grateful for your feedback and any kinds of criticism and discussion, because it's very much something, as you've probably read or as you will see, it was really rather than being a full research article as we know it, it was really an essay in the original sense of the word. So maybe I can just briefly introduce how I got familiar with this topic and what interested me and why I chose to write it in the way that I did. So my initial interest was really about I can't move the screen. Yeah, I can do it like this. My initial interest in this topic was mainly derived from my curiosity about how a legal tribunal, especially a human rights commission, would interpret the notion of climate justice, but also in what ways scientific knowledge would get transcribed and transposed into legal reasoning. I also have a history of science background, and I'm interested in modeling and simulation. And I knew that climate models are, on the one hand, based on historical data, and even what that data means is very much contested. But all the projections that we have, so the IPCC report about the 1.5 degree change, for example, it's based on a range of parameter that then get modeled into futurity. So in a way, you could say these are simulated features, and they are very much derived from historical data, but at the same time, they are speculative in that sense that they have specific premises behind them. So how do we actually reconcile such a one way of knowing into the legal ways of knowing, which really, needs an elaboration between legality and illegality, between past harms and future harms, and also we are very much delimited by the legal formats and the ways of knowing that we have. So I saw a gap, and perhaps I was just really curious about how the commission would go about doing it in reconciling scientific knowledge, especially evolving knowledge, with human rights principles. So this was really my motivation to look at it, and the other concern that does drive my research, not just in this area but also in other areas, is how do you reconcile the abstraction that every legal principle and doctrine is together with lived experiences. So it's very much a question about the ethics and modalities of representation in law. So when you look at this slide, you can see there are two different representations of the event. One is a photograph of the devastation that Typhoon Haiyan caused in the Philippines in November 2013. And 5 years later, we see the same event being discussed in a moot courtroom at the London School of Economics. And the moot courtroom was used in order to host the Philippine Human Rights Commission's inquiry into the human rights violation that carbon major companies may have caused. And it was initiated in 2015, and there are 3 hearings, first in Manila, and then in New York at Columbia Law School, and then at the LSE, which I observed as an observer in November 2018. So these are vastly different settings and experiences. And I think us as lawyers, of course, we have to exercise lived experiences or facts of a case into legal matters. But at the same time, it is actually quite a different experience when you sit in the same crowded courtroom next to lawyers that represent the carbon major companies, and right next to them are Greenpeace lawyers. And then in the next row is actually a sufferer of the Typhoon Haiyan herself, who also gave testimony. So you know that the lived experiences are vastly different. And as a researcher, how do we actually do justice to these vastly different experiences in our work? So just some background about the facts of the case. Typhoon Haiyan that devastated the Philippines in 2013 was the strongest tropical cyclone ever recorded, and it surpassed existing typhoon classifications. They had to actually devise a new category. The highest level until Haiyan was category 3, but a new category of level 5, so-called super typhoon, had to be invented after Haiyan. It caused approximately 6,201 deaths, more than 27,000 injuries, and the displacement of nearly 4 million people. But this is not the only singular catastrophic typhoon that is beyond the abnormal level of harm. The frequency of harmful weather also results in an accumulated effect of anomalous level of harm. So for example, Philippines suffers from more than 20 storms a year on average. So one of the testimonies included the fact that this is not the only typhoon that should suffer. They already had to move home twice because they were affected and lost their homes in previous typhoons. So Philippines is one of the countries that's being one of the most vulnerable to the effects of climate change, to which it had hardly contributed. And most countries already do or will suffer from climate change effects, are the ones that did not contribute to the accumulated and now exponential effects of human-caused climate change. So although we can see that the term climate change describes past events and experiences, as a reality, it actually denotes something very abstract. It's a statistical anomaly that is based on scientific models. And of course, we cannot feel a calculated probability. Arthur Kessler wrote that, and I quote, "Statistics don't bleed. It is the details that count, and we can only focus on little lumps of reality." So turning climate change into a legal matter then is perhaps a difficult and broad attempt to form such little lumps of legal reality without an overarching claim to representational veracity of the relationship between nature, earth, non-human, and humans. So what really puzzled me is actually are the different scales that are involved in climate change as a planetary problem. And I don't even know what it means that something is a planetary problem. I think we have different words to denote what is happening to the entire globe, but at the same time, we are divided up by nation states, jurisdictions. There are different perspectives that we can take. So I think the problem of scale was really acute to me. How do we reconcile different perspectives of scaling? We focus maybe on little things such as, the lovely weather here today, but then we might have a hard time realizing how different it might be perhaps for someone who is suffering from the effects of a typhoon. So I started to think about how to reconcile different scales. And of course, there are different notions of scales in law and in sciences. One, I think, scale that we are very much familiar in legal scholarship is the figure of the scale as a balance. And Mario Biagioli has written a really interesting article about scales, figures of scales in law. And what he says is that it's actually quite it's quite unclear what exactly is being balanced. So on the one hand might be harm suffered, and then on the other hand might be the remedy, but what is exactly achieved by balancing the scales? So we have to figure out justitia as a figure of balancing or scaling, but also we think about scales as measures or as literally like a measurement. So we say, what is the scale of a map, for example, right? You can zoom in or zoom out. So all of these things are very much involving questions of representation. Then scales, again, is very much different from simulation, because scale is supposed to be observing something that can be represented and that can be perhaps also quantified. But simulations are something that is not a representation of something that exists, but we actually project it into the future. So like all of these questions very much make me think that in law, from our perspective, from our human perspective, the scale of our importance is an inverted and perhaps also perverted relationship to the planet. So in a almost like anti-Copernican mode, in law, the world is comprehensible only if it revolves from our perspective around us and humans. And when we think about other kinds of legal actors and agencies in law, such as non-human legal personas, such as corporations, it still requires our human mediation to make them intelligible within the legal discourse. So in the legal hearing, climate injustice are materialized and particularized into the human narrative scale. So I started to go about this notion of climate justice by separating the composite term climate justice into climate and justice. And so I started with justice. And what I found really interesting was this quote by Jacques Derrida. I think it's worthwhile to read out a bit of it, because it interestingly, he actually talks about calculation, which is something that I think in jurisprudence we don't really talk about very often. We think about law as an interpretive or discursive project, as an endeavor that entails human judgment, very much textual, but it doesn't really, we don't think very much about the calculative aspects of law. So I quote, "That justice exceeds law and calculation, that the unpresentable exceeds the determinable, cannot and should not serve as an alibi for staying out of juridical political battles. Left to itself, the incalculable and giving idea of justice is always very close to the bad. Even to the worst for it can always be reappropriated by the most perverse calculations. And so incalculable justice requires us to calculate." So I think what is really interesting here is that the double meaning of value, so value in normative sense, but also value in the sense of quantified value, is both present. And Derrida is really thinking about this contradiction between incalculable justice and calculable justice. So justice is what law cannot know, according to Derrida, and yet seeks as its unrepresentable essence. This raises the question why justice is still expected to be achieved through legal means, and whether human justice could ever, even remotely, claim climate justice, particularly when the meaning of climate itself is an abstract one. So matters or issues don't speak by themselves without the help of rhetorical, spatial, and temporal frameworks. And that is why the set of techniques and mediations through which they become material need to be examined in order to concretize the meaning of justice. So this is this was part of the broader project about trying to get to a more critical and also perhaps a more precise understanding of materiality in law, because as perhaps many of you might know, there are two strands of materiality. One is really thinking about the embodied experiences and embodiments in different kind of legal discourses, especially I think in gender studies and feminism. Embodiment has become quite an interesting concept to work with. The other thing is that the so-called new materialisms, so theories of new materialisms, kind of, they actually take on the importance of embodiment, but at the same time, it's not entirely clear how embodiment in that sense can be represented and incorporated into legal discourses or legal concepts. So there is a fundamental friction between abstraction and embodiment in many legal doctrines. So in our project, where we actually explored this notion about what is specifically legal about legal materiality, we argued against a simplistic understanding of materiality as physicality, by saying that certain materials such as computers, screens, networks, databases, physical persona can become enlisted into legal reasoning, and they give body, so to say, to legal matters, matters of concern in law. So the legal matters, as we know, are usually abstract. It might be standing, it might be a criminal matter, it might be a property matter. So all the legal doctrines that we teach our students are abstract concepts, and these are within the internal legal understanding, these are the legal matters, but then it often fails to take into account the embodied experiences. So this means that the processes and the mediations by which legal matters become meaningful to law is not self-evident, and they need to be explained. And the idea of climate justice then may be located in the gap between legal matters, and in this context, it might be international human rights principles that the Philippine Human Rights Commission is examining, and the reality of enacting this legal matter in a courtroom or in a proceeding like this. The other part of the composite term climate justice is climate. And what I really wanted to define here is that contrary to the embodied experiences of beautiful weather like today, or a horrible weather event such as the typhoon, it's not exactly the same meaning as the word climate in strictly scientific terms. So the World Meteorology Organization defines climate as, and I quote, the measurement of the mean and variability of relevant quantities of certain variables, such as temperature, precipitation, or wind, over a period of time, ranging from months to thousands or millions of years. And the average period to determine what is normal climate or abnormal climate is 30 years. So in strictly scientific or meteorological term, weather is not the same thing as a climate. So Gabriele Grummelsberger, who's a philosopher of science, points out that the notion of climate involves both a scaling up of historical, local, and singular data, which are then taken as proxies and extrapolated into uniform data and data sets. These in turn are modeled with algorithms to make an assumption of a climate balance as a zero-line normal base case from an average of the past 10,000 years. And the deviations from such statistical mean value is then interpreted as climate change. So climate change is not what we experience in scientific terms, but it's a deviation from a statistical mean value. So it's very much calculated. So in rhetorical terms, when we talk about climate justice, we encounter it a lot in various, newspapers, common non-specialist discourse. People have different ideas about what climate justice is. I'm not saying that one is right and the other one is wrong, but I think it's interesting to take into account what climate justice means or might mean in current jurisprudence. Increasingly, the term climate justice has closely become associated with an invocation of international law of human rights, together with the aim of development. And this is from the UN Special Rapporteur on Extreme Poverty and Human Rights, who actually mentioned climate justice explicitly in this report. And it assumes, or it is based on the premise that justice is a human matter, and that human suffering ought to be remedied in order to benefit politically underrepresented groups. But despite, or precisely because of its avowed link to legalistic and universalistic vision of human rights, climate justice may never stabilize, perhaps, into a coherent or overarching set of legal matters, that is to say, doctrines or legal principles. Paradoxically, because of its planetary scale of the problem. So climate justice is a planetary scale of problems, but then in order to scale it down to individual human rights, you need to prove the cause and effect relation, and it has to be recognizable to legal modes of reasoning. So what is remarkable is that so far legal claims for climate justice have been marked by fragmentation of non-binding, binding, and yet not enforceable domestic and international legal obligations, agreements, and law. So in order for a scholar to observe how climate justice is increasingly figured as a legal matter, examining its materiality can help to break the complex matter down to its appearance, partial manifestations, experiences, and materials. And these can include the text of the petition, in the room of a landmark climate justice hearing, the testimonies, the gestures and facial expressions of panelists, witnesses, audiences, technology such as PowerPoint slides, the position and movement of video camera. So these are the ingredients that enable the idea of climate justice to attain legal reality. So I think at this point, I think it's interesting to show you, just to give you a sense of what the hearing looked like, and how how informal and friendly it was. It really felt more like a conference than a legal hearing or a procedure. And I was really interested in how this inquiry, which did not really have a jurisdictional force, and inquiry meaning also it's not a adjudication or adversarial decision-making process, how this actually came about. And without really going too much into detail about multi-level governance and all that, I think it was clear that the making of the jurisprudence of climate justice was very much driven by people who were already connected in a different forum in one way or another. So there is a very strong sociological element of associations and people driving this jurisprudence. So the petition was brought by Philippine individuals, and Greenpeace assisted them with making the legal claims. And then the various research institutions, such as the Grantham Institute at LSE, they then provided the room and the facilities and also the funding to actually, assemble all the witnesses and the travel. So here, what you see is a performance of legality rather than a setting of adjudication. And this was a format which was very much open, and it was mediated by technology, and it happened in multiple places. So the hearing was live streamed and also uploaded onto video, and people could observe the hearing very easily on YouTube. and there were then all networks. So the Manila hearing, the New York hearing, and the London hearing were all put together. So in a way, I mean, it's quite remarkable how this became quite an international or transnational matter of concern, rather than being restricted to one specific jurisdiction. So you can see at the back of the room over there, these were the members of the Philippine Human Rights Commission. On the right-hand side by the window was the table where the expert witnesses were giving their testimonies, and kind of resembling like a courtroom setting. On the left-hand side, you have the clerks taking protocol and doing all the filing and paperwork. And in front of the commission were the lawyers for the petitioners. And then you had a very big audience, and the audience was, I mean, it really resembled a conference more than anything. The people were coming in and out, but there was a clear spatial separation between two doors. That door was only reserved for the commission and the legal officers, and then the other door on the left-hand side was for the audience. So let me just say a few words about scales in law and science. My initial interest in the hearing had focused on the way in which inquiry would transform scientific attribution principles and risks into legal responsibility and liability, and they needed to do that by reference to so-called attribution science. Attribution science was a relatively recent strand of climate science, and it calculates and attributes a defined quantity of greenhouse emissions to individual companies and countries. And it's very much based on Richard P.D.'s 2014 report on carbon major, and it formed the central scientific foundation for this particular legal inquiry. And it broke down the emissions to the largest carbon producing companies and states. So this meant that the inquiry's remit of investigating human rights violations that were allegedly caused by carbon major companies in the Philippines required a reconstruction of the linkage between historic greenhouse emissions, their contribution to climate change, and legal obligations and responsibility not to violate them. In other words, the strength of legal reasoning rested on scaling down climate change models, linking past emission data based on past company meteorological data across different spaces, jurisdictions, and actors, to typhoons that devastated the Philippines. In turn, established the relation between all of the foregoing to human rights violations suffered by individual petitioners. So you can see what a huge endeavor this is and how difficult it is to attribute exactly that the petitioners suffered harm as a result of Shell emitting so and so many greenhouse emissions. So I was expecting a detailed questioning into the assumptions of Richard Healy's report on attribution science, because the scale and complexity of proving the plausibility and soundness of the petitioner's claim was extraordinary and would require the linking of three scales of the individual, legal, and scientific experiences and modes of reasoning. But to my surprise, the climate sciences, including attribution sciences, were not opened up and were left intact as truth statements. So what is really odd is, and I think it's very much taken for granted, is that the legal internal processes and formats stay relatively the same. So we talk as if the outside of the world, put it in quotation marks, is rapidly changing and law has to respond to outside changes. But the legal internal processes and formats, despite the plethora and varying scales of different issues, tend to stay the same. So, for example, in the case Liuya versus RWE, which is still ongoing in Oberlandesgericht Hamm in Germany, is using the property law about harm caused by the melting glacier on the plaintiff's piece of land. So this is, in essence, this is a pure property claim. We also know that environmental law or other climate change laws are not necessarily about large international treaties, but we use existing mechanisms that are available as legal remedies in order to address something which is much larger in its actual scale. So how can the alleged facts be linked to legal conceptions of human rights? How do you give legal shape to a plethora of phenomena that were both experienced, but also at the same time, they represent numerical calculations? So during the hearing itself and afterwards, the Commission did not explicitly relate the state of scientific knowledge to a legal finding of human rights violation. There was an expert's testimony by Miles Allen, who is also part of the IPCC group, and he's a climate modeling expert at Oxford. And his statement attributed the intensity of storm levels to human influence. But in my understanding of his testimony, it appeared just short of establishing an unequivocal causal link between the responsibility of carbon majors to the human rights violations suffered by Philippine citizens. So the hearing did not attempt to construct a coherent causal or teleological narrative. Rather, it resembled a formalized, legally formatted, dissonant polyphonic sequence of expert statements. The orders of testimonies were disconnected. So the first day proceeded in this order: a UNICEF official, then a UCL environmental scientist, then there was an ethical pension fund advisor by the Church of England's pension fund. And then that was followed by a testimony by the lawyer acting for Luya against RWE. So these 2 days reflected a fragmented totality of climate justice as an idea which would remain bound by pragmatic constraints, such as who would be available when, and traditional legal formats and procedures, and was not really reflective of the idea of climate justice that ought to encompass a multi-scalar, transdisciplinary, multi-species perspective. So the picture of a whole climate justice as a concept or as an idea in relation to situated parts, such as testimonies, graphs, PowerPoints, Zoom links, lawyers, cameramen, academics, files, screens, furniture arrangement, were left to the observer to piece together. And that seemed to be, to me, a more truthful and reflective state of the current kaleidoscope of conflicting realities than an adversarial adjudicatory format could achieve. So what happened during those 2 days? And I think I'm very much aware that this commission hearing was quite special. I mean, it wasn't the normal litigation case, but I think this kind of hybridity made it so interesting. So what happened in these last 2 days, and when I think back of it, I would read of it as not an event that tried to establish legal causality, but the primary mode of relating the different testimonies and concerns was a different one, and I would characterize it as affinitive juxtaposition. So the hearing engendered a spatial and linguistic association between climate science and human experience, by bringing together abstract scientific and personal knowledges and their different ways of knowing, such as mathematical models and simulation, as we saw here. This is a simulation of different wind speeds and and then the amount of human influence. So brought together this with the testimony of a victim of the typhoon, and they all brought this together into a common space. Also, the Human Rights Commission withheld from explicitly drawing relations between them. So they were not giving any interpretations at the hearing. They stressed the fact that this is a conversation and a dialogue rather than adversarial hearing. It did also not translate the concept of climate into a legal idea of justice. Rather here, the idea of law seemed to act as a distinctive attribute, so an adjective. Something was a legal testimony, something was a legal file, this was a legal inquiry. And that imbued a shared quality amongst all the elements that had otherwise not much in common. So the legal inquiry conjoined words, people, and things loosely, despite compressing climatic space and historical time into 2 days in a medium-sized room. So the mere juxtaposition of diverse knowledges of the same problem, climate change, with its different phenomena produced associations. Greenhouse emissions became associated with legal responsibility. So the hearing invoked affinities between disparate parts through juxtapositions, and that is to say, a literal putting next to one another. So this was my interpretation of what was going on in those 2 days of hearing. And from a lawyer's perspective, it might be quite frustrating because we are not, we are not presented any kind of conclusion or a solution or remedy. So I think what is interesting here, and then I think I'll end with open questions, is that where does this leave us? I think looking at matters or legal matters of concern that are evolving, especially around, so the law itself is evolving and nascent, such as the jurisprudence of climate justice, in relation to events or facts that are also changing, such as in the case of climate change. Everything is in a flux. So I think for these kind of evolving matters, the idea to focus on mediations, techniques, and materials are quite useful to figure out what exactly is happening as a diagnostic approach. So it's quite different from, let's say, applying the concept of power, Foucauldian power, to a certain set of events or circumstances. So it's less top-down, concept-driven, the interpretation, and it's more, I would say, diagnostic in the sense of trying to figure out what is actually going on. This might be helpful, especially with nascent or evolving legal matters, but also it might help to bridge the focus of research between particulars. So, we focus on particular experiences, individuals, set of concerns, as opposed to abstract or universal, because legal doctrines are always, well, they have to be abstract and universal in order to be applied to a certain set of facts. A materialist approach might also be helpful to think about the different temporalities involved that are being manifested in legal practice. So I think especially with climate change, there are past, present, and future temporalities that are always present that need to be negotiated. So the focus on concrete materials, media, etc., they're helpful here. But having said that, I'm also very much aware that materiality as an approach might not always be useful. So it very much depends on the object of research and object of inquiry. So I think I'll stop here. Talked enough. And I'm happy to take any questions and points of criticism. So thank you very much for listening.
Thank you so much.